Good morning. I thought since this is a young lawyer sort of focused event, I would, since there aren't that many of us, just have us go around the room for a minute and just give our name, where we're working, and how many years we've been practicing, just so that I have a little bit of idea of who's here and sort of how I should tailor it. I'll start. I'm Mary Moses. As Trish said, I'm with Last Moses and Ramp, and in about 2 or 3 weeks, I will be having my 20th anniversary as a family law attorney, which is horrifying. Okay, how about you, sir?
Jerry Porter, 40 years, but I'm about 15 years out of what used to be 50 to 85% concentration in family law, but I have a daughter with 4 children who has an alcoholic ex and he's endangering the children. She said, "Dad, I need help."
I need help.
So I'm here to brush up.
Sounds good. You, sir?
My name is Edwin Kaus, 35 years. I'm Mr. Porter's paralegal.
Great, thank you for coming. Natalie,
Hi.
you're talking.
I'm Natalie Simpson. I work at Sher Putman Akins Lamb. I am going into my 7th year.
Hi.
We're introducing
I missed
ourselves.
Okay, I was going to say I missed what it was we're doing, but I'm Jamie Cage. I'm a partner at Cage Bucar Lewis, and I've been practicing for almost 10 years.
Thanks.
Tony Adjacent, I'm the Director of Metro Volunteer Lawyers. I've been practicing off and on for about 23 years.
Ari Gould, I have a solo practice here. I've been practicing, you think 20 is long? 30. My 30-year anniversary is coming up this fall, and I actually have a couple of cases that are pertinent to this issue right now. So as somebody announced the program this morning said, brushing up on things is always a good idea as well.
Great. You, sir?
I'm Matt Dolan. I work at Block and Chapleau, and this is my first year.
Very glad you came.
Well,
Hopefully this will help.
I get a lot of that.
Chuck?
I'm Chuck Turner, the retired executive director of the Bar Association. I've been admitted to practice. Admitted to practice for a long, long time.
Perfect.
I'm actually here as a proxy for someone who could not be here, and so I'm planning to pass on some information, I hope, to this person.
Great, thank you. You in the suit coat?
I'm John Rainwater. I've been practicing labor and employment law for 20 years. So I'm here just to learn.
Great.
My name is Sarah Myers. I'm actually the clinical director of our lawyer assistance program. So I'm an attorney, but I'm not in practice right now. I take care of you guys.
Thank you.
I'm Lauren McDaniel. I work at Cox, Baker & Page, and it's my first year as well. So.
Super.
And then my name's Christy Bush. I just finished my 2nd year of law school, and I'm Mary's law clerk at Last Moses and Ramp.
So we have a wide range of experiences in the room, and this is probably, I think, the 3rd or 4th time I've given the presentation. It's not getting any better, but I keep giving it because I think the issues that we're going to talk about are things that keep coming up in our practices over and over again, and each time it's a slightly different nuanced situation. Each time someone's making a slightly different argument, and it never hurts to have the refresher of, let's go back to the basics. What are the standards? What do we have to prove? So today we're primarily going to talk big picture, which is the standards for modification of decision making and standards for modification of parenting time. I include in that restrictions on parenting time. We'll also sort of, since we're talking about standards, we will touch a little bit on when you're dealing with third parties, because you always have slightly different standards when you have parents, biological parents versus psychological parents or guardians or things like that. So we'll touch a little bit on those issues so that you're aware of the differences. You will notice at the top of my materials Catherine Beck, who I hope most of you all know, she has given this presentation with me in the past and has helped me develop these materials. And she is a great resource if you all don't know her. She does a lot of CFI work, she does a lot of mediation work, and then a lot of client representation. And she's always available as well if you have questions. All right, so let's start. One of the partners at my old firm, whenever you would go to him with a question, would say, well, I don't know. What does the statute say? So we will start with what the statute says, because it's a very fine place to start. The standard for modification of decision-making. The first line is the court shall not modify a custody decree or a decree allocating decision-making. I'm just going to pause with that. So remember, the starting point is you're not going to modify it unless, right? Unless what? And the statute starts out by saying, unless the court finds, based on facts that have arisen since the prior decree, so either new facts, or that were unknown to the court at the time of the prior decree, so either new facts or newly discovered facts, that there's been a change in circumstances of the child or the child's custodian or party to whom decision-making responsibility was allocated, and that the modification is necessary to serve the best interest of the child. So I want to start with that. I had just last week, someone filed a motion to modify decision-making, and one of their arguments is the dad is a new man. He didn't used to have sole decision-making, but now dad's a new man. The addictions are over, you know, he's getting his life back together. Is that a change in circumstance for the child or the custodian or the parent to whom decision-making responsibility was allocated? I'm going to make the argument that it's not, right? That, you know, mom's still doing great, child's still doing great. There are no changes of circumstances with those two. So just because the other parent has had a major life change, that doesn't fit the standard of the statute. Who knows if that'll work? Okay. So you got to have a change, and that the modification is necessary to serve the best interests of the child. But remember, that's a bit of a red herring, that when you are dealing with modification of decision-making, you need to be thinking about the endangerment standards. So even though the first part of the statute talks about best interest, that's probably not going to be enough to warrant a change of decision-making. Okay. In applying these standards, the court shall retain the allocation of decision-making responsibility established by the prior decree unless, and then we go through the five criteria that would warrant a modification to decision-making. A, the parties agreed to the modification. I've never seen it. You all will never see it. It's a unicorn. Okay, B, the child has been integrated into the family of the petitioner with the consent of the other party, and such situation warrants a modification or allocation of decision-making responsibility. This is perhaps less likely, but if more likely than the agreement, but still, you don't often see this. I haven't really seen much case law. There is one case that talks about what it means to be integrated into the family. We can go ahead and skip to that. The integration case is, if you look on page 3 of your materials, In Re Marriage of Chatton. The court defines integration as more than a mere expanded visitation. So it's not just that you used to have one overnight a week and now you've got 2 overnights a week, so you should have decision-making. It includes performance of all the normal parental duties, washing clothes, providing meals, attending to medical needs, assisting with homework, guiding the child physically, mentally, morally, socially, and emotionally. I I think the important part, and the one that seems most significant to me, is that the time spent with the parent must be of sufficient duration that the child has become settled into the home of that parent as though it were his or her primary home. So this integration seems to me like it really is that the child has a new primary home, and that's what is going to count as integration for purposes of Section B for changing decision making. A related factor is B5. There has been a modification in the parenting time order pursuant to 1410-129 that warrants a modification of the allocation of decision-making responsibilities. I think this is an interesting one, and again, it's coming up in this case that just was filed a couple weeks ago on one of mine. Mom's been the primary parent. Dad is now asking to have equal parenting time. And Dad is arguing that by moving to equal parenting time, it requires a modification of decision making. Now that this child is with me 50% of the time, or I hope to have this child with me 50% of the time, as a 50% parent, I should have joint decision making. I think that's a pretty unique legal argument because in my experience, most people aren't getting sole decision making just because one parent doesn't have equal parenting time. It's not like, oh, you've got 20% of decision or 20% of parenting time, you've got 80%, so I'm giving you sole decision making. There's usually something a lot deeper going on that results in the sole decision making. So I would be surprised if just moving to equal parenting time satisfies this B5, but someone is very legitimately making that argument, and perhaps you can too in your practice. It feels to me like this is more like mom was the primary parent, now dad is the primary parent. Dad needs to be the one deciding on schools. Dad needs to, it feels like a bigger thing than just increasing parenting time to me, but I do not have a black robe. So that's my gut. You all can argue it as you want. B7, a party has consistently consented to the other party making individual decisions for the child, which decisions the party was to make individually or the parties were to make mutually. So in other words, over the course of the past few years, there's been a de facto change in the decision-making process, that someone who didn't have decision-making has been allowed to make the decisions, or someone who had joint decision-making has abdicated their decision-making role. You don't see that very often because people usually cling to this decision-making with the vice grip. So,
Quick question on that.
Please do.
Is there a specific period of time where you think that would kick in, like 1 year, 3 years, or is it, in terms of that kind of change, if a party has kind of dropped out of the joint decision-making thing?
The question is, and I'm sorry, I have to repeat it for everybody because you all don't pick up well. Is there a period of time over which this deferral of decision-making needs to be in place? I don't think so. It just says consistently. I think that's probably whatever consistently means. That's your standard. Okay, and then the last one is the one that everybody is, I think, most familiar with, and the arguments most people make, which is that the retention of the allocation of decision-making responsibility would endanger the child's physical health or significantly impair the child's emotional development. The person with decision-making is making bad decisions, right? That they are making decisions that endanger the child's health or impair their emotional development. This is where everybody gets creative. What is endangerment of physical health? Sure, it's easy if somebody's not perhaps getting vaccinated and there's a whooping cough epidemic. That might be a pretty clear physical endangerment. I think typically what you see is either failing to make decisions that need to be made, and the child's just sort of languishing, not getting the help for their dyslexia that they might need, things like that. Or perhaps more realistically, this is when the parents just disagree on every single thing that's happening with the child. And so one parent wants to make a move to either become a joint custodian or to have sole decision making. The other part of this final endangerment factor, and I'd be remiss if I didn't mention it, is not only do you have to prove endangerment, you have to prove that the harm likely to be caused by the change of environment is outweighed by the advantage of a change to the child. Harm likely to be caused. That doesn't make sense. Trish?
It means the harm that's likely to be caused by the
New.
decision-making is outweighed by the current harm.
Yeah.
Bird also says, I just read the annotation, that you have to show a benefit also.
Right, and I think the benefit goes back to that very first part of the statute that talks about this change has to be in the child's best interest. So even though we're in these factors, don't forget to go back to the first part of the statute that says where the change needs to be and that it needs to be in the child's best interest. I think where people get tripped up when it comes to modifications of decision making is because we have the statute itself seems clear enough, but the case law, I think, has muddied the water a little bit, starting with In re the Marriage of McNamara. In McNamara, the parties were allocated equal parenting time and joint custody. And I am using the word custody deliberately, old school language. In McNamara, the parties had joint custody, had equal parenting time. Disputes arose, and they both wanted sole custody. So they both asked the court to have sole custody. And the question is, what standard applies in that situation? What the court said in McNamara was that when you start out with joint decision-making and joint custody and equal parenting time, that is basically a deferral of the custody decision. So the court hasn't really weighed in on it. I think that's a fiction, but whatever. It's our fiction. And therefore the standard is best interest. So if you are in a situation with joint custody, equal parenting time, and someone wants to change to sole decision making, it's a best interest standard, according to McNamara, because that initial decision was a deferral. Do you have a question?
So obviously the bad acts of one of the parents or the other would make a difference. Locking them in a room, doing things like that.
The question is, do the bad acts of one of the parents impact this best interest decision? Yes, absolutely. Is this parent able to make child-centered decisions, things like that? Yes, another question.
I'm just curious as to why you're referring to it as custody instead of APR.
Right. Why am I referring to it as custody versus APR? Because McNamara was decided prior to our use of the term allocation of parental rights and responsibilities. Then see In re Marriage of Stewart, which is the next case, which does it does answer the question, is joint custody the same as joint decision making? The answer is yes. The same rules apply under our APR statute. So there was some question when the statutes were rewritten whether there was a modification of the standard. The answer is no. It's still, if you have joint decision-making authority and equal parenting time, the standard to modify to either parent to have sole decision-making is best interest. All right, next case sort of addressing what standard to apply is Marriage of Newell. In Newell, the child lived primarily with mother. And so there's not exactly this deferral concept. Child lived primarily with mother. Mother had sole decision-making in most areas, but the parties had joint decision-making in 3 areas. Surgical decisions, behavioral medication, and life-threatening conditions. Let me just pause there for a second and sort of admire how in the Newell case, the judge got, or the parties got really specific about how they were divvying up decision-making responsibility. It wasn't just joint decision-making on medical, it was joint in these specific areas, and I just think that's instructive because we could perhaps learn from that and anticipate problems when we're drafting our initial agreements. Anyway, they have joint decision-making in these 3 limited areas. Mom then filed a petition with the court so that she would have sole decision-making in all areas, including those 3 carve-outs. The evidence that she put forward to be able to support that modification, again, she would have had to prove endangerment because it was not a deferral. She had to prove that the child was endangered. The way she did that was by presenting evidence of the parties' lack of agreement and lack of cooperation. So, in other words, saying, I know we have joint decision-making in these 3 areas, but this child is endangered because every time we have to talk about medications, it's a fight. Every time we have to talk about surgery, it's an argument. And she was actually able to present evidence that we had a fight about education to support a modification in these 3 areas. So Newell, I think, is really an important case when you are trying to prove that joint decision-making endangers the child in some way. I think Newell is your go-to case for what you need to rely on. There is also a constitutional discussion in Newell about a parent's ability to communicate with the medical providers and whether or not you can limit a parent's ability because you have a constitutional right to free speech and you want to give input. And it says that a parent's exercise of free speech rights can be limited if they threaten the child with physical or emotional harm. We talked about Chatton, just having to do with what is integration. In re marriage of Rosie is the next case that I cite. I don't find it particularly helpful or illuminating. This is the case where the parties entered into a parenting plan that provided for the allocation of parental rights and responsibilities until the 2-year-old child turned 5 years old. And the question, and sometimes you'll see that, we agree to do this, but then we'll reevaluate it when the child is 5 or is entering school or something like that. The court, I think, sort of sidestepped that real question, which is what is the standard in those situations. But it does lay out a little bit about who has the burden and things like that. It says if a parent requests a modification of decision-making, he or she must demonstrate that based upon facts which have arisen since the prior decree, that a change has occurred and the modification is necessary to serve the best interest. But if the party seeking a modification of decision-making responsibility makes that necessary showing, the court must still retain the allocation of decision-making responsibilities unless one of the circumstances set forth in sections A through C, the statute we just went through, is shown to exist. So it sort of says read the statute, which I think is a stupid case. Okay. Let's see. Okay, I think I have a little bit of time just to talk about modification standards for third-party cases. These are cases where a third party has some sort of parental rights allocated to them. The first is parental responsibilities of BRD. A couple was given sole decision-making responsibility for the child, and the child was in their primary custody. The father then filed a motion asking for some decision-making responsibility to be allocated and to have more parenting time. The Court of Appeals held that because father had a constitutionally protected interest in the child's care, custody, and control, and again, those third-party caregivers do not have the same constitutional protections, a different standard exists for modification in those circumstances. So when you have a third party versus a biological parent or a legal parent, there is a presumption in favor of modifying the decision-making and parenting time orders consistent with the parent's request. So there is a big finger on the scale in favor of the biological or legal parent based on their constitutional rights. The third party has to overcome that presumption by showing that the proposed modification is not in the child's best interest and to prove that the existing orders are in the child's best interest, and they have to do it based on a preponderance of the evidence. In re the matter of DIS, this is that first case, BRD, was an allocation of parental rights and responsibilities. DIS is what happens when you have given permanent guardianship to another set of people. And again, following Troxel, the Colorado Supreme Court said that special weight must be given to a parent's decision to terminate the guardianship. And the guardians had the burden to show by a preponderance of the evidence that terminating the guardianship was not in the child's best interest. So if you're ever in that situation, read DIS. It lays out a bunch of standards. The point being, again, legal and biological parents have special weight in modification proceedings. Similarly, I'm going to skip ES. That has to do with temporary guardianship, which really isn't worth much at all. And then in re parental responsibilities of AM. In the absence of a showing that parents are unfit, grandparents must prove by clear and convincing evidence that parents' decision to terminate grandparent visitation was not in the child's best interest, or to prove by clear and convincing evidence that a continuation of the grandparent visitation would be in the child's best interest. So again, grandparents, while they may get grandparent visitation rights, it's kind of hard for them to hold on to them over time. Dealing with motions to modify decision-making, one of the important things to just have in the back of your head has to do with the timing of the filing of the motions. 1410-131-1 says that if you file a motion to modify decision-making, whether it's granted or not, you have to wait 2 years before you can get another bite at the apple. So you can't be bringing these motions every year hoping that the new judge will see things your way. You have to wait 2 years after the last one is ruled on, unless continuation of the existing custody decree or allocation of decision-making would endanger the child's physical health or significantly impair the child's emotional development. Well, chances are that was the standard you were using to bring the motion anyway, so it seems like an in run. Anyway, yes, sir. All right.
You said you have to wait 2 years from the date of the order, but isn't it
No.
first in the filing?
I'm sorry.
Okay.
It's you have to wait 2 years from when the last motion was filed. And a distinction I want to make is that if you get your permanent orders in 2012, you could file a motion to modify decision-making in 2011 because that initial permanent orders isn't what the statute speaks to. The statute is speaking to motions to modify decision-making. So in other words, if you got your permanent orders in 2012, someone could file a motion to modify in 2013. You would then have to wait to 2015 to file the next modification of decision-making. Yes, Trish.
Sorry to interrupt. I just bring this up because I did have this issue in another case of mine where the mother was really out of control and was constantly trying to modify decision-making because my client had sole decision-making. And so we were looking to invoke the 2-year rule as frequently as we could. And this actually was a case with Catherine Beck, who was our arbitrator. And the way we approached it, she and I, in terms of our perspective on that 2-year rule, was that it was 2 years from disposition of the prior motion. So the permanent orders, there's no limit, and then you have the first modification, and then, because that was a case where the disposition took 1.5 years from when it was originally filed, and so then we started the 2-year clock from disposition to the next filing.
Yeah, Trish is correct. It's not 2 years from the filing of the motion, it's 2 years from the filing, or from the disposition of the motion. So if you stretch that out for a year, you bought yourself more time. In applying this standard, there is case law that says you need to look at actually the substance of the motion. So like if the motion says it's a motion for modification of parental responsibilities, but really all they're trying to modify is parenting time, that doesn't invoke this statute. You have to look at really, are they trying to modify decision-making, regardless of how the motion is sort of captioned or whatever. The issue that I see come up often is the question of the parties have joint decision-making, and mom wants the child to go to school A and dad wants the child to go to school B, and how do we resolve that? And I actually think that there are 2 lines of cases on this, and I have seen courts adopt both lines, which, is horribly confusing, and good luck to you. The first line of cases is that it's Griffin v. Griffin, and this is a 1985 case. So this one was, but it's Supreme Court, and it was decided, obviously, under custody statutes. And this is the case, many of you all may have read it, it's the one where mom decided she wanted to send the child to a Buddhist school, dad objected, and asked the court to select the child's school if the parties were unable to agree. The Colorado Supreme Court referred back to a statute that I don't think a lot of us look at much, which is 1410-130, Section 1. And the Supreme Court concluded that the joint selection of schools provision in the separation agreement was unenforceable, and that instead the custodial parent retained the ultimate authority to select the child's school pursuant to 1410-130. So, in other words, the court's saying, look, I have no authority here. All I can do is say which of you two is the primary parent, and the primary parent gets to decide the school, even though you have joint decision-making. Fast forward 20 years to in re marriage of, I pronounce it Dawei. If anyone's got a better idea, that's fine. This is a Court of Appeals decision, which to me seems to go in the opposite direction. Mother asked for authority to enroll the children in therapy over father's objection. Father asserted that the trial court was required to make a finding of endangerment before modifying decision-making, right? That seems legitimate. But the Court of Appeals disagreed. They noted that the lower court did not change the allocation of decision-making. Rather, they concluded that the court had resolved a long-standing dispute concerning therapy, and that the court was not prohibited from resolving a major decision where the joint decision-makers were unable to do so. So this says to me, if you have a disputed major decision, you could go to the court and ask the court to make the decision. I asked the court to do that the other day, and the court said no. And I said, thank you, sir, we'll work it out on our own. So that's the case on that.
What is the point of even having joint decision-making is if there's a disagreement, then it defaults to the primary resident, primary custodian. That doesn't seem fair to the other party.
The question is, what's the point of having joint decision-making if the statute allows you to default to the primary custodian to make the decision? Nobody ever looks at that statute, I guess is the answer. And Griffin, I think, has some questionable validity given the changes of our decision-making statute. So that's why we earn the big bucks, is to argue this stuff. Because if anyone else, I mean, this is an area I think if anyone else has experience and wants to share it, it would be helpful. But that's, courts hate this stuff. And recently I did have a case where the parties did have joint decision-making, and every single decision was a battle. And that was grounds for the court to modify to sole decision-making, just because when you can't reach agreements over and over again, something's got to give. And so it's a long war, and each one of these decisions can be the battle that, anyway. Yes, you have a question?
So you're saying that Griffin isn't really, that this statute, this statutory provision isn't really cited and relied upon much, but in this case it was a separation agreement. Do you think it would have mattered if it were an order, permanent orders, where the parties didn't come to an agreement on what decision-making that they?
The question is, what do you do with Griffin, and sort of can you distinguish it on the grounds that in Griffin they're interpreting a separation agreement as opposed to permanent orders where decision-making was allocated? I don't know, because I think it's interesting because not only was it a separation agreement, but there was this very specific language that says, we shall agree. And there is sort of this concept that you can't enforce a future agreement to agree. So I don't know, you know, most of your separation agreements say we have joint decision making, and if we don't agree, here's our dispute resolution mechanism. And sometimes in there you put, you know, if we can't agree, we'll go to mediation. If we can't agree at mediation, then a court shall decide. Presumably that sort of language would give the court some authority to be able to make this decision. So old case, old language, but there's a magistrate in Jeffco that still follows it, so, you know, it's out there. Yeah, Natalie.
Have you seen a case where parties have joint decision-making and then there's a protection order, a permanent protection order between the parties, and then what happens with decision-making?
How do you do joint decision-making when there's a permanent protection order? I think usually courts, even when there is a permanent protection order between the parties, try to find some way for the parties to communicate, be through talking parents, through you know, whatever, through a decision maker, through so I think, in my experience, courts try to hold together joint decision making however they can, but I certainly think that if the permanent protection order was something that happened after the fact, that's a modification or a change of circumstances, and if the parties aren't able to communicate at all, perhaps that is endangerment justifying sole decision making. Because in all of my cases, they tell us to work it out, figure it out. So, all right, I am going to move on because the hour is growing late. I'm going to skip over the stuff, but there is stuff in the material sort of about how this all interplays in juvenile court, both in dependency and neglect and paternity proceedings. Okay, moving on to modification of primary residence. same sort of statutory framework. The court shall not modify a child's primary residence unless the child's current environment endangers the child's physical health or emotional development. It's the same sort of idea that you retain unless the parties agree to the modification, the child has been integrated into the home, or there's endangerment, or then there is the special category of relocation. So when the primary parent wants to relocate, the court could deny that relocation request, thereby transferring the primary residence to the parent that's staying behind. And you wouldn't have to prove endangerment. You would just have to go through all of the chess-lick factors on the relocation stuff. So I'm not going to talk too much about relocation. Instead, I want to talk about how this statute is applied in real life when people are seeking to modify parenting time. First of all, I think everybody knows, but it's if dad has 2 overnights per week and dad wants 3 overnights per week, that is just a modification of parenting time. That is a best interest standard. You don't have to worry about meeting any of these extra criteria of agreement or integration or endangerment. If you're not, it's only a question of if you're seeking to modify the primary residence. That's when the standard gets tricky. So marriage of Newell, these are the people that couldn't agree on behavioral medications. The separation agreement provided that the child would live primarily with mother. Father requested that parenting time be modified so that the parties would share, quote, roughly equal parenting time. The Court of Appeals held that if all you want is to go from a lesser status to equal parenting time, the best interest standard applies. That going from mom being primary to the parties being equal is not a change of primary residence, and so best interest is your standard. So when I think about parenting time, I think of a fence. And this is equal parenting time, right up here at the top of the fence. And so if dad's down here, to get to the top of the fence, he only has to prove best interest. If he wants to get over the fence, where he's primary, that's when you have to prove endangerment. But if you are sort of on the top of this fence, and you're going to fall to either side, that's going to be just best interest. If you just want to get to the top of the fence, it's best interest. It's when you want to get over the fence, that's when endangerment applies. Let's see. Other sort of nuanced features of that. I think marriage of Niskern is an important case when you are drafting separation agreements or getting your court orders that you need to be thinking about. In Niskern, the separation agreement granted the majority of parenting time to mother, but there was a condition in it that said, but only on the condition that mother stopped alienating the children from the father. It was perhaps more artfully drafted, but that's the concept. Father then filed a motion to modify the children's primary residence on the grounds that mom was still alienating the kids. So the question was, again, dad was trying to change from mom being primary to dad being primary. Did he have to prove endangerment? And the court said, no, all dad's doing is enforcing this separation agreement because the separation agreement says that mom's only primary if she's alienating. When dad goes to trial, the only thing to prove is whether or not mom's alienating. If mom's alienating, you enforce the separation agreement and the kids go primarily with dad. So that's sort of a way to get around the endangerment standard is if you built into your original orders mom's primary, but only if she follows these rules, and then mom breaks the rules, perhaps you just need to prove that the rules have been broken, not endangerment. Interest of DRVA just says that paternity proceedings, you look to the DMA and apply the same standards. So if you are in a strictly paternity proceeding, just apply your regular 1410 standards. The interest of CTG is an interesting case. It talks about the difference sort of between interim orders, temporary orders, and permanent orders. There were orders issued out of a different state, I forget, like Minnesota or something, saying that this is an interim order and stepdad is going to have all this parenting time. And the interim orders went on for 3 years. But the court then said, this is just a temporary order, so this is a deferral. So we're still in the initial, permanent orders have never been entered, so the best interest standard applies, even though there has been a status quo for 3 years. It's sort of a fake status quo, I guess. So just make sure that the order that you are trying to modify is in fact a real permanent order. All right. Restrictions on parenting time. We'll deal with those for the last few minutes. A court shall not restrict a parent's parenting time rights unless it finds that the parenting time would endanger the child's physical health or significantly impair the child's emotional development. In addition to a finding that the parenting time would endanger the child's physical health or significantly impair the child's emotional development, any order imposing or continuing a parenting time restriction, in an order imposing or continuing a parenting time restriction, the court shall enumerate the specific factual findings supporting the restriction. Make sure the courts do this. This is a modified statute. There was a legislative move a couple of years ago from a group of parents that had restricted parenting time, and they're like, we've got restricted parenting time, and we don't know what we need to do to be able to get our unrestricted parenting time back. So the court has to really lay things out so that the restricted parent has some benchmarks that they can then later come back and say, I have now met my benchmarks, I should have unrestricted parenting time. There's also 1410-129-3, which talks about if a parent is convicted of certain crimes, there's an automatic assumption that their parenting time should be restricted. And if your client has committed one of these crimes and the other parent moves to restrict, you have to respond within 21 days. If you don't, if the offending parent fails to respond within 21 days, the parenting time rights of such parent shall be suspended until further order of the court. So this is not one you can ignore. If you're ever in this situation, you need to respond right away. But in those situations, the offending parent shall have the burden at a hearing to prove that parenting time by such parent is in the best interest of the child. Yes?
I've got one question.
Yeah.
Would you dare in either of these two subsections of 129 attempt to do it solely on a parent's testimony, or would you be much more comfortable starting out either with a psychologist or a competent CFI? What are your recommendations with respect to utilization of experts in these two subsections?
How do you prove endangerment at trial is sort of the question. Do you need an expert? I think it depends on the type of parent's issue. The parent that gets arrested for DUI with the child in the car probably don't need an expert. You know, I think a court's gonna recognize the inherent dangers of that situation. I think that when you have drug and alcohol use and you're able to establish that the child was present when this was happening, I don't know that you do need an expert in terms of establishing the initial endangerment criteria. Now, as things drag on and, you know, courts love everybody getting rehabilitated, right? And so the question is, the longer they stay sober, how long should these restrictions stay in place? Then I think you do need to have your experts come in. If you have parents that are just making bad, non-child-centered decisions, like, you know, grabbing the child and screaming in their face, and that sort of emotional endangerment, I think courts greatly appreciate having the expert weigh in. I often suggest that if the child doesn't have a therapist, that you get a therapist so that the child has a way of expressing their emotional turmoil to someone that then the therapist can then talk to the CFI, can talk to the PRE. Someone that's able to talk about what this conflict or whatever this is doing to the child internally, whether it's a play therapist that's seeing these things acted out, or I'm thinking of the case I recently tried where the PRE was able to say, you know, with the weight of an expert behind him, Mom keeps talking bad about Dad and Dad's Iranian heritage. And the PRE said, these children are half Iranian, and so every time Mom talks about how bad the Iranian culture is, that is diminishing the girl's self-esteem. And I don't know that we would have been able to present that testimony without the PRE in that situation. Yes?
In terms of the recommendation that child get into therapy, what if, can a parent do that on his or her own if the other parent doesn't agree that therapy is appropriate without having to file a motion?
How do you get a child into therapy where there's joint decision making and the offending parent disagrees? See in Ray Marriage of Dawei. I think, yeah. No, you can't. A good therapist will not treat a child without finding out what the orders are and getting consent of both parents. There are therapists that do not follow that protocol, but there you go. Motion to restrict parenting time, you know, you have 14 days to file that, or not to file that, sorry. When you file a motion to restrict parenting time, it is automatically affected, and there has to be a hearing within 14 days on your allegations. Do they rise to the level of endangerment? Did you have a question?
I was just going to say, when parents don't agree, at least for school-age children, you can encourage, the parent can encourage the child to go talk to their school counselor, and then you can use the school counselors.
As an expert.
Yeah.
Yeah, the comment was that one way to sort of do an in-run around the joint decision-making therapy problem is that schools often, school counselors will often see children without both parents' consent, and so that may be something that, that can be done. Okay, I just want to briefly touch on, because my time is about up, In Re Marriage of Hatton. This is a 2007 case. It's talking about restricting parenting time. When the court is, if the court finds that the child is endangered and that they are going to enter restrictions, the court must consider whether there is a less detrimental alternative to ending all contact between the parent and child. And I would say it's probably not just between ending all contact, but when the court is imposing restrictions, it needs to be the least detrimental alternative. Again, because we want parents and children to have relationships, we have to do whatever we can to make sure that happens in a safe way. Let's see, marriage of Fickling, temporary parenting time orders do not grant parenting time rights that would necessitate application of a higher child endangerment standard of proof to revise such orders as part of permanent orders. So remember, even though you get temporary orders where one parent is the primary parent, you still may get permanent orders where the other one is primary parent based on best interest. It doesn't have to be an endangerment standard. In re marriage of West, what is a restriction of your parenting time? I think it's like pornography, you know it when you see it, right? What is a restriction? I don't know, but in West they say reducing parenting time from 8 weeks in the summer to 6 weeks in the summer is not a restriction, it's just a reduction. There's a difference between a reduction and a restriction. Let's see. Oh, and then most relevant to the people we see today is on page 12, in re marriage of Parr and Lyman. This is a case where dad was using marijuana and then he got his medical marijuana card, and it says that the trial court erred by imposing a supervision requirement without a showing that father's marijuana use endangered the child physically or impaired the child's emotional development. So whether it's marijuana, alcohol, or whatever, you still need to prove the endangerment before you do a restriction. You can't just assume that alcohol or drug use is endangering. Unless you're in the car for the DUI, then I think you can assume it. Okay, my time is up. I can take a couple of questions, but I also know people need to get places. Yes?
So when you were talking about the fence analogy, so if you have 50-50 parenting time and one parent then wants to have the majority of the time and reduce the other's parent to like every other weekend,
Mm-hmm.
where are we? Is that a restriction?
Where are you? So the question is, if you have equal parenting time and one of the parents wants to significantly reduce the other parent's parenting time, like to every other weekend, what's the standard? Is it best interest or is it endangerment? My analysis of it would be that it is a best interest standard because you're not changing the primary residence, so that statute doesn't apply. And then it becomes a question of whether reducing from equal time to alternating weekends would properly be considered a restriction of parenting time. And I would argue under West, no, it's just a reduction of parenting time. A restriction might be something more like you only get weekend parenting time and it has to be supervised, or you can't use drugs or alcohol, or some other condition being placed on the parenting time, not just a reduction. On the other hand, if I represented the other person, I'd be arguing that that is a restriction. But I would think best interest is the controlling standard. Any other questions before we head off to work?
It sounds like some of these permanent orders are looked at as deferred judgments. Can they be argued that way, that we didn't know exactly what was going to happen in the residence, the permanent residence that was given at the time? I mean,
yeah, I think that's right. I think that is what McNamara and Stewart says, is that when you have permanent orders where it is equal parenting time and joint decision making, that is a deferral, and that we'll sort of wait and see, and if problems arise later on, then you can modify based on a best interest standard.
you don't have to show endangerment then, you just show that was a wrong decision to be made at that time.
Right, you don't have to prove endangerment under those two cases. All right.
Thanks, Mary.
Yes.